Okay, so I'm going to try and stand. I might have to sit if I can't read my slides too well, but we'll see how good my contact lenses are. But I just prefer to stand. So I just want to talk about some of the changes that have happened with our protective order statute, specifically HB 403. The intent with this statute was to create a much more accessible, understandable collection of the orders of protection that are available, and to create uniformity where possible, which means some of the orders and the criteria of them has changed, but we've tried to collect it all into one place, which means all this confusion will now be under one area. Unlike, however, the drug statute, which is confusion under one area, hopefully this one is much more clear. So this is the layout of 78V-7. As you can see, protective orders and stalking injunctions. And I've listed the chapters in there just for quick reference. We've got the general provisions, child protective orders, uniform interstate enforcement, the dating violence, sexual violence protective orders, then the cohabitant abuse protective orders, civil stalking injunctions, criminal protective orders, and that also includes the JRA, JRO, the jail release agreement and order section, and then criminal stalking injunction. So we've created, and this is in the materials section on our website, as well as in the toolbox now. So if you go into the domestic violence protective orders, you'll find this chart. We've created this chart just as a quick reference summary. By all means, if you're looking at the information for these, please go to the statute, but just as a quick reference, some of the changes we're having shown on this. So just to get a little closer view, and I am going to have to sit for this because my contacts apparently aren't that great. So the jail release agreement, and you'll see we've listed the statute by each of it so it's easy to find. So when you're flipping through and you need to pull it up, you can do that. So jail release agreement issued by, one change here is that now law enforcement can issue this when they're releasing on citation. So that's a good change that helps, especially since we've now launched into, what we've been dealing with COVID, and the jails have had some little tighter restrictions on who they'll accept. The duration, again, till midnight of the scheduled court appearance or 30 days from arrest. Some of you are in areas where the courts, because we're not having court, the courts are setting them out beyond the 30 days. That is not an exception to this expiration. Your victims need to know that. Your survivors need to know that, which means they still only have 30 days and they'll need to look at doing perhaps some other kind of order of protection or getting a jail release order extension from the judge through some other means that you could assist with. Pretrial criminal protective orders, sentencing criminal protective orders, these just terminate same as they have before. Continuous protective orders and the criminal stalking injunctions are the only permanent orders that we have now. You may remember, those that have been around, the old days when we had civil protective orders that were permanent. Then that got changed to 10 years, and now it's been changed to 3 years. The civil protective orders are now only 3 years. Civil stalking injunctions, and just a reminder, you should know this, but we don't see a lot of these at times. The civil stalking injunctions do not have to go to a hearing in order for there to be an order. So the ex parte, the temporary order that they get, if the respondent does not request a hearing, automatically transitions and becomes the order, and then it expires 3 years after that. Continuing on down, this is the civil, the cohabitant protective orders. So civil protective orders, now only 3 years. So I've confirmed with the AOC in the court, they are not, this is not retroactive. So as prosecutors, when you're looking at cases, you may look at a protective order that is permanent, or it might be 10 years, or it might be 3 years. So we're going to have to just make sure that we cross that T and dot that I, that we know what the actual duration of that order is. Child protective orders, there's a couple variations of those. We see less and less of those for a lot of reasons that those dealing with children in the juvenile system understand, but just be aware of those. Dating violence, sexual violence. Now, dating violence protective orders, those used to only be for 18 months, and now they're for 3 years. So that's another change. And again, that was to try and create the uniformity of of having a 3-year term for as many of these orders as possible. So not just that we know, but more importantly, that the citizenry at some point can just have an understanding that, oh, those kinds of orders, those are good for 3 years. And they know what protections they have and what limitations they have depending on what side of the order they're on. So that is available in the toolkit, the toolbox, and on our website. A couple other reminders. Just be aware that information has to be entered into UCGIS for our law enforcement or for us to be able to see it. So when you're working with your law enforcement, remind them that if the victim, the survivor, is saying, hey, that's been served, but it's not showing served in UCGIS, they just need a good faith belief that it has been served. So they need to ask more questions of the survivor. Find out when was it served, how was it served, who was it, that served it. They should have some information, perhaps if they were there at the time it was served. We don't have to rely solely on UCGIS. Accountability is really important in domestic violence cases. And so just because it hasn't been updated doesn't mean that we shouldn't be proactive in making sure that we're providing that protection where that protection is needed. Another service reminder, ex parte is served, but the respondent doesn't go to court. Sometimes that doesn't show up on the system in a way that seems clear. It'll show ex parte is served, but protective order is not served. If the ex parte was served, even if we are now past the court hearing date, what the statute says, and I've given you the reference, is that that ex parte remains in effect until that actual order is served. The intent, of course, is to make sure that the victim doesn't have a gap in protection just because Joe Schmo or Susie Joe doesn't go to Susie Schmo, that's a tongue twister, doesn't go to court. So be aware of that reminder. Avoid charging decisions where possible. Sometimes we're under the gun and we don't have time, but if you have not already figured this out, you will. UCGIS is not always accurate. It's not always complete. My best practice, and I probably drove my legal staff crazy because I'd say, I want the order, get me the order, call the court, I want the order. I wanted the actual document to see what the judge has signed and what was written in handwriting and what was not. So just be aware of that. It's a good faith place to start. It is sufficient in many situations just to rely on that, but we want to be very careful that we are charging and or declining based on what was actually ordered from the hearing. And then try and avoid, prioritizing the severity of violations. We all look for what's in the interest of justice, but just a reminder that domestic violence and the terroristic campaign of, intimate partner violence, it includes 1,000 pinpricks of misery. And so you may have a violation of a protective order that just seems petty and very minor, but our survivors often get left to suffer and die by 1,000 pinpricks. So if it is a violation, try and just take a step back. Yes, we are looking at the interest of justice, but don't forget that campaign of domestic violence, it involves all those subtle, tiny pricks of misery, and that's one of the most common ways that they have they maintain control. It's continual little things as opposed to the big things. So, Utah Domestic Violence Officer Reference Guide. This has now been created. I actually had this idea a few years ago when I was prosecuting. These look a lot like the criminal code books that Post puts out and the FST booklets that you probably referenced for your DUI cases. We've now created, and fortunately I met the mastermind behind those two, Sergeant Mark Thompson with Highway Patrol, and I was doing a domestic violence training with him, and he goes, do you think it would be helpful if law enforcement had a quick reference for domestic violence? And I got giddy with excitement. I was like, oh my gosh, yes, this would be such a good idea. And so we collaborated really quickly and got this in the works. Due to lower travel for Utah Prosecution Council, I had some extra money. We were able to fund it. So we have these books available. We ordered enough for every law enforcement officer to have in the state. They were disseminated in the same way that the criminal codes or the criminal quick reference and the the FST quick reference was, and that was through Highway Patrol. I have also got in the material, so please check the list. There is a list on there of what areas Highway Patrol has sent these books out to, which means your area may not have access to them yet. If your office is willing to be the go-to point, you can give us a number of how many books you need. We will provide them to you for your county. Just for cost and ease, we'd like to have one disbursement point for each county. But if your county has not yet got one, please check that list, let us know, get us some numbers, and we'll send you the books so that all of our folks have these books. They're a great resource, and we have enough extra for prosecutors as well. Again, for that purpose, a great resource. So here's just a quick glance at all the things that we have in this booklet. We've included everything we could possibly think of without having to have it, hardcover bound due to size. We wanted it to be a quick reference, but lots of great information in here that we want to put at the fingertips of our law enforcement and our prosecutors. We've also been contacted by the court. They've had some problems with protective orders not being accepted in the national system. And the reason is due to lack of information. So specifically, we're talking about criminal pretrial protective orders, continuous protective orders, the ones that prosecutors are involved in. So not the cohabitant, the civil ones, the dating, those ones are done by the petitioners. But these are the ones that we as prosecutors are involved in. So there's a couple slides on that. I'm not going to go through it in detail, but I do want to stress the importance of us making sure that when we're doing one of these orders in court, before we pass it off to the court, that we have this information on the orders so that once they put it in, it does get accepted. We have circumstances where, a prosecutor will say, there's this order out there and it's not on the system. There's a reason why it's not on the system. It was missing what they consider to be their bottom line identifying information that they have to have. Here's an example. There's more than one person with Michael Jordan as a name. My husband's name is Rodney Wayne Jones. There's a guy named Rodney Wayne Jones, exact same birth date, exact same everything, and we're both from Canada, so every time we go across the border and then we try to come back in, my husband gets all kinds of looks. To my husband's advantage, the other Rodney Wayne Jones is African American and 6'6". My husband is not either of those. So we usually can get through, but there's always a stall. We have to wait. Will you come inside? And he has to say, look at the picture. Clearly, it's not me. So identity is an issue. And we want to make sure that we've got these orders listed against the right people so that we can enforce them against the right people and protect the right survivors and the right victims. So just some interesting statistics of the cases. And then the statute involving the language dictating what information has to be on these orders, and then quick reference. So this, and I've given you the contact person, his name's Daniel Levin, he's with the AOC. If you have questions about this checklist, which is also going to be, it's in the toolbox, this checklist, just a quick reference for prosecutors to make sure we've got the right information. So a little closer view of what that includes. It's all on one sheet. Just make sure that you've got that information listed so it can make it all the way through the process. When we pass it to the court, it's easy for us to think, okay, we did it, it'll go, but there may be stopping points after it leaves our hands, and we want to make sure that that doesn't happen, that information does get put in. And there we have it. Clear as mud. If it makes any difference, I found the ball, so now I'm passing it off to you. It's in our toolbox, and it's in the materials. If you have any questions, you're welcome to call me or to call Daniel Levin on the other court entry information. And then please let us know. We have boxes of this at UPC still. We want to make sure we get it out to the hands that need it, so let us know. Thank you.
Thank you, Marlesse. Okay, let's take we won't do a 15-minute break because Steve is here ready to go. So I've got 3:18 here. We will start at 3:30. 3:30. 3:33? No, 3:30. 3:30. Okay, see you guys.